Hello everyone, welcome again to this Expert Speak section. Last Tuesday, we started our conversation around property dealings, buying and selling for the NRIs, and we looked at the legal complications. As I said, it's a very vast, exhaustive subject. Because of the time constraints, we considered few points. In this episode, which is part 2, we are going to discuss more complications around property dealings. What are the things that you should keep in mind? We don't know what type of properties you're buying. We are trying to cover as many points as possible. Please stay till the end of the video, and it's going to be a referral video for you to fall back on whenever you decide to buy or sell the properties. This is NRI Money Clinic for you, and I am Dr. Chandrakant Bhatt, your financial guide for a happy living.
NRI Money Clinic. No hype, just the right advice.
Nivesh, Desh Videsh 2025, organized by NRI Money Clinic to celebrate the completion of 5 years of knowledge sharing and gaining on 21st and 22nd February 2025. Watch it on Zoom from anywhere in the world, or watch it live or at your convenience. Learn from the wisdom of experts. Dive into the world of experience of maestros of investment industry and explore opportunities to invest and discuss. Be enlightened on engaging in contemporary topics such as mutual funds, alternative investments, annuities and cash flow solution for retirement, fixed income solutions in INR and dollars, solving the NRI dilemmas, investment opportunities from Gift City, NRI taxation, USD investments for NRIs, smooth transfer of inheritance. Hear from our distinguished speakers from around the globe. On the keynote address, we have Mr. Navneet Manot, MD and CEO, HDFC AMC. Dr. Dipesh Shah, Executive Director, International Financial Services Center Authority, Gift City. Mr. Gop Kumar, MD and CEO, Axis Mutual Fund. Mr. Akhil Chaturvedi, Executive Director and Chief Business Officer, Motilal Oswal AMC. Mr. Amit Pibalkar, Founder Director, Sapient Finserv Private Limited. Mr. Ashish Somaiya, ED and CEO, White Oak Capital Management. Mr. Rahul Prasad, CEO, HDFC International Life. Mr. Sudarshan Lodha, Co-founder and CEO, Strata Capital. Mr. Saurabh Bhatia, Head of Fixed Income, Sapient Wealth Pune. C.A. Sriram Rao, Partner, Nitin J. Shetty & Co. Mr. Jatin Popat, Founder and CEO, Viljini. Mrs. Elizabeth Roy, Head, Product Management, ICICI Prudential Life. Don't miss this golden opportunity to listen to the stalwarts in the field. Mark your calendars and register now for this wonderful event.
Dear viewers, just to remind you, this is part 2 of this episode. We had done part 1 before. I'll ask my editing team to show the thumbnail of the previous part. For a comprehensive knowledge around this buying and selling of properties and its legal complications, it's advisable that you watch part 1 too to get a complete information about it. Mr. Naik, welcome again.
Thank you, Financial Dr. Bhatt.
Mr. Naik, properties have got so many legal complications. Let's discuss now the minor interest. When somebody is trying to buy a property and the property has a minor interest which is built in it, and if it is suppressed or if it is neglected, what complications might come in?
Normally, whenever there is minor's right in the property, if you want to buy that property, better the guardian takes permission from the court. And whatever as per the court directions, whatever mentioned in that is to be followed. Say for example, minor's consideration out of some amount should be deposited with the minor and it will be matured only when he attains the majority. All those clauses may be there. Or if it is for the necessities, education matter or any of the minor requirements, then The person who sells the property has to convince to the court, and court has to give the direction. Normally it takes more time, so people avoid and they go for shortcut. What they do is minus portion also, including that they buy, but minus portion they make it as a deposit in the name of the minor. But there is a risk loaded in that, because once the minor attains majority, the minor can any time challenge the transactions. So the title of the property which you have bought may be at stake. So my suggestion as well as advice to the purchasers of property, whenever you go for purchase of minor right properties, always insist for court order, and as per the court directions only you have to follow the transactions. That is the advice.
One another common type of dealings that happen is NRIs are outside and they carry out transactions with power of attorneys. Either they give power of attorneys or the seller on the other side might be giving power of attorneys. Many times I feel it's a dynamite of a problem. If everything goes well, that's perfectly fine. People take power of attorneys, gets into all kinds of dubious transaction. So the buyer or seller, if it is mediated through a power of attorney, what precautions need to be taken?
Normally, power of attorney means on behalf of the principal, his or her agent is acting. So it will be binding on the person who gives the power of attorney. If the power of attorney is executed when NRI has come down to India, then it can be executed in front of a notary, or even registered power of attorney can be done. In that case, adjudication is not necessary. There are two types of power of attorney, that general power of attorney and special power of attorney. General power of attorney means it gives more powers, sweeping powers. Special power of attorney means for particular purpose.
Specific.
Specific purpose it will be given. If NRI is in abroad, then power of attorney can be drafted here and it can be mailed in a plain sheet only. He can take printout. He or she can execute that in front of Indian embassy in that particular country. And they can again courier back, and it should be adjudicated with the district registrar by the attorney holder. Normally the attorney holders will be the close relatives, father, mother, brother, sister, spouse or children. So they are the attorney holders. If it is third party, if they are giving power, if it contains for mortgage or it contains for sale, in such case the stamp duty also it will be higher amount. So these are all the implications of power of attorney transactions. And whenever they give power of attorney, it should be very, very specific, and it should be clearly mentioned. It is only for purchase of property and to mortgage in favor of so and so bank when they take loan, represented before the sub-registrar while registering the property, and subsequently applying for whatever connected khata and other things. It should be restricted, and it should be clear. This power of attorney does not entail the person to sell or any other matter. Like that, better to mention. So general power of attorney, it contains detail, and person who purchases the property under the power of attorney, suppose is the recent past, there is no problem. Even still recent past also, better to take confirmation that I have given so and so power of attorney in favor of so and so, and this particular transaction is with my knowledge, and I hereby have no objection for executing on my behalf, my attorney executing this transaction on my behalf in favor of the buyer. If it is clearly taken, then it is better. Then if the power of attorneys are pretty old also, even bankers also sometimes they mail to the person and they take confirmation. So better to take confirmation of the that power of attorney. If it is pretty old, better to have latest power of attorney, because nobody knows what are the implications of that. So any power of attorney transactions, you should be extra careful.
See, in some of the purchase and sale dealings, one of the things might happen is there is a tenant in the property, and the deals happen with the tenant in the premises. Are there any care that needs to be taken around that?
Definitely. See, if it is old tenants, if the rent is very low, better to have latest rent agreement with the tenants, increased amount, or you can vacate the tenant. If you want them to vacate, then you have to vacate the tenant, and then only you have to buy. Even in case of vacant lands also, proper boundaries are to be put by the seller itself, and you have to inquire with the neighbors if there are any issues in that vacant land, or if the property is vacant land, better to have proper measurement by the city surveyor or surveyor in case of village, and better to have surveyor's sketch, and that is to be attached with the sale deed. So this much precautions better to take. Without proper boundaries, better not to buy such properties. And drainage, suppose there is a drainage as per the corporation limits, or that drainage it passes, that also you should be very careful. Then some cases high tension wire will go in that property. That's why I am insisting the buyer to physically verify the property before buying. So high tension wire, if it goes, there is a rule. I don't know exact, but it may be 30 meters on the both the sides, nothing can be done. Or property situated adjacent to national highway or state highway, you cannot do any developments. You cannot construct any building from highway so and so meters. CRZ regulation I told, riverside properties, seashore properties. Then one more check is to be done, whether the property is coming under the purview of any government acquisition for road, for industrial board or anything, railways, all these things. After ascertaining all these things only, better to buy the property.
One another common observations are people often talk about is the heavy stamp duty which comes along with property dealings. To save on the stamp duty, they try to do things in an undervalued way. What is the precaution people have to keep in mind? It should not be done. It's not law. But you have seen on the ground what happens. Some of the things which definitely needs to be avoided, and keep your transactions above any suspicion or in a good way so that you can part with this property in due course of time. What is the message you have for us?
See, undervaluation is a serious issue because every state government, they have guidance rate, guidance value for each locality property, and you cannot register the property below the guidance value. But if you register the property below guidance value, sub-registrar will register provided you pay as per the guidance value stamp duty, because state government is bothered about as per the guidance value minimum stamp duty is to be paid to the exchequer, either as per the guidance value or as per the sale deed value, whichever is higher is to be paid to them. But here one catch is there. Under the Income Tax Act, there is a section 50C. Under section 50C, if you are registering any property below the guidance value of the state government, the difference between guidance value and actual sale transaction value, it is deemed to be capital gain for the seller. It is deemed to be deemed gift for the buyer. So in such case, what happens? Deemed capital gain means on that difference, whatever capital gain, if it is short term, 30%, if it is long term, 20%, capital gain is to pay. Now, of course, they have reduced that 20% capital gain rate with effect from 22nd July 2024. They have reduced it to 12.5%.
Right.
In case of property, long term capital gain from sale of properties. So for the buyer, this is deemed gift, because when suppose the value of the property is 1 crore guidance rate and you are buying for 75 lakhs, the 25 lakh difference is deemed gift, And if the deemed gift other than from relatives, it is taxable as income, as a regular income, around 30% tax. So this is the threat is there. For this, under section 50C1, one exception is there. Up to 10%, there is a tolerance limit. Up to 10% lesser than the guidance rate, it is tolerated in income tax. But as per the state government stamp duty is concerned, you have to pay stamp duty at the minimum guidance rate. This
So
is the-
income tax will take its cut.
Yes,
State government will take its cut.
yes.
It's just that the professionals will misguide at some point of time to say that we can do all these things.
Professionals will not misguide. People should go to a, see, if you are not well, you will not go to a known doctor. You will go to a best doctor. Like that here also, whenever you do all these transactions, you go to a best advocate and best chartered accountant with the proper name and fame, and those who are in the panel of the reputed banks or financial institutions.
Often people consider gifting the property instead of selling. Let's say between one brother selling to other, they will gift. Are there any complications, precautions that needs to be taken?
See, gifting of the property, sometimes to avoid income, if it is income generating property or subsequently income will generate, many people plan by way of gift. Husband gift to the wife, commercial complex for example, rent is coming. If it is divided between two, tax will be less or it will be below bracket. But under section 64, clubbing provision is there. If the transaction is between the spouse, if you gift, the person who will gift, because without any consideration under section 64, the person who will gift, in his hands only, this income will be clubbed. So clubbing provisions will be there. So to avoid, you cannot do this. But one is for wife and another son's wife also. Daughter-in-law also, this provision is applicable. But if you give to your daughter or your son or your brother, sister, mother, father and all, this problem will not be there. So it will not be clubbed in the hands of the person who transfers. So that will be there. Another thing is, if you gift just for tax purposes, tomorrow that property will be done away from you. So that also you should be very careful. Just to take some small benefit, you should not incur big risk. So what I say is, for small benefit, you should not forego big benefit.
One very common mode of buying or selling today is under construction properties. Builders announce properties. People will exchange properties during the under construction phase. What is the thing one should keep in mind to avoid the complications?
See, under construction properties, you should go to a reputed builder only. People with the proper name, fame, and earlier
Financial muscle.
track record, and their antecedents you have to check. If they are reputed under construction property, you have to take some calculated risk. Of course, it is available at bit cheaper rates during construction, because after completion the rates will rise. You have always calculated risk, and you have to check the RARA provisions. As per RARA agreement, everything uploaded in their website.
Mr. Naik, now you have assisted countless people during your career. Whenever I come to your office, there is a flood of people who are always waiting to get your attention there. What is the common mistakes people make? Most of the times, instead of taking proper precaution, asking people, lawyers, chartered accountant, and the concerned people, people will just go by and gets land into trouble, and then they come for solution for this. What is the mistakes people make, particularly the NRIs?
First is cash transactions. In property, you are not supposed to do the cash transaction. Under section 269 SS of the Income Tax Act, if any person sells the property and receives in cash 20,000 or more, equivalent amount penalty is leviable. So in property transaction, please don't go for cash dealings. That is my first advice or suggestion to the people. Second thing is, just to avoid stamp duty, reduce the stamp duty. Many NRIs from NRI account, they withdraw cash and pay in cash. Then also there will be a track. There are a lot of transactions, because now all transactions are PAN based. Everything will be noticed by CCTV of the income tax department. That CCTV will inform you what you are doing. You may forget, but they will not forget. And all the transactions what you are doing, it will be reflected in your 26 years also. You should be very, very careful. Next is rental income. When NRIs get rental income, even 1 rupee if the person resident pays to NRI, they have to deduct tax at 30%. So they avoid, they don't disclose that NRI. That is also another mistake they do. They have to apply under Form 13 and get 13A form certificate from the assessing officer. Then it can be done at lower rate or nil rate. Then if any property is, they are constructing houses and all, own house construction, villa and all, 50 lakhs and above, if they make to one contractor, then tax is to be deducted, TDS is to be made while payment to the contractor. If the rent, they stay in a rented house, parents or their relatives or their wife or their children, 50,000 and above, if you make rent payment, then again you have to deduct TDS. And if you pay NRI to NRI, then TDS will be from rupee 1. So all these precautions are to be taken. Then this section 50C, I told that guidance rate, that is to be very, very careful. It will be made known. Better register the property at the value which you have agreed only. Tomorrow unnecessarily that complications will not arise. But of course, in some cases, that is anomaly. Guidance rate as per the government is much more than actual transaction. In such cases, one provision is that you can register the property at agreed rate, but sub-registrar will refer under section 45 of the Transfer of the Property Act to the district registrar. Then district registrar will come and verify the spot. Then he will determine the actual value.
So in cases where the property has a disadvantage,
Correct.
it cannot be parted at the guidance value.
Correct.
Specific circumstances, leakage, drainage, non-utilizable land,
Correct.
or something like that. And in
Correct.
such cases, it's purely on genuine grounds. So the checks and balance comes in the form of referring to a higher authority.
Correct. And higher authority can verify, and he will determine the value. At that value, you only have to pay the stamp duty. But if you are still aggrieved, you can file a writ in the court. Because fundamental right, purchase of property is a fundamental right. If still it is not possible, then no other go except to go for writ in the court. So ultimately, for every problem, there is a solution. But my final advice to the people is buyer beware. You buy only property, don't buy problem. Take your precautions before buying the property. I am not telling that you don't buy the property. You buy the property. Take your proper precautions. Even while buying one dress, ladies, if they want to select one sari, they will see minimum 100 or 200 sarees, then they buy one sari. Even small shoes we want to buy, we will take so precaution. Then why not when we buy the properties? So advantage of buying the properties, one thing is there will be normally appreciation of the property, either due to inflation or there will be normal appreciation because of the scarcity. Second thing is, when you buy a property out of loan EMI will remain same, whereas the property value will skyrocket. That is the advantage. Appreciation. Third thing is, if you are buying rental properties, the beauty of rental income is, if you have other income, if it is taxed maximum at 30%, rental income will be taxed after 30% of the standard deduction. That will be applicable rate is only 21%. The beauty in rental income is, you are ending up in paying maximum 21% tax instead of 30%. Second thing is there will be appreciation. Third thing is whatever rental regular income, that is passive income you are getting every year, minimum 5% increase in the rent will be also there. This is the triple benefits when you buy a property. But there are some problems also if tenant is vacated. If you have commitment to our EMI, that is threat is there. Then due to some widening of the road, there will parking space is occupied by the government. No parking. In such cases, you have to make again distress sale. There are advantages, there are disadvantages. Before buying the property, take care of all these things and enjoy the property and reap the benefits of appreciation of the property, income of the property, and if it is own resident, satisfaction and contentment by staying in that property.
Mr. Naik, thank you very much for all these inputs. It's really, really exhaustive. Your experience speaks here. You have seen so many cases, and it's a wealth of information. All that I can say is thank you very much for your time, your kindness to spare that precious time for the benefit of my audience.
It is my pleasure to be associated with NRI Money Clinic. You are disseminating knowledge across the globe for non-resident Indians. Definitely many of them got lot of benefits because of your regular videos and regular enlightening sessions.
Dear viewers, hope the video we have done has enriched you with the knowledge about property purchases, buying and selling. If it helped you to understand how you can carry out these things in a legally correct way to avoid the complication, please do give me a thumbs up. By the way, if you are somebody who is yet to subscribe for the channel or watching this channel for the first time, please do hit that subscribe button right now and press the bell icon. Do not forget to share these videos with your near and dear ones, friends and relatives, and on all the social media handles on which you are connected with. Thank you very much for watching this episode on NRI Money Clinic. I shall be back with you with yet another expert next Tuesday. Till then, stay safe. Jai Hind.
Press the bell icon for more details and subscribe our channel.